Helen Slottje, an attorney. She's currently engaged in environmental law and in community law. So Helen, welcome to Norwich.
So, well, terrific. Well, thank you for coming out tonight. And so I'm Helen Slottje. I'm with the Community Environmental Defense Council. We're a public nonprofit law firm based out of Ithaca. All we do is work on environmental and municipal community rights type work. And so I understand that this is the third in a series of presentations that have been here. For how many of you would this be your first gas drilling meeting? So, all right, a few. Many of you, this is, probably, you've been to a number of these. And so tonight's topic is on the legal rights of local governments, home rule versus the DEC's regulatory system. And so I thought I might open a bit with sort of what is the general point of the regulatory system and how has that worked with industry, how historically has this process worked. And so you've been to a few of these meetings, you sort of might feel like you listen to the same thing all the time. And when you look back, even past sort of Marcellus issues in New York State, you'll find that a lot of the issues, it's quite extraordinary how the same things get repeated. So in 1925, when the Ethel Corporation was really trying to sell lead, they needed to find a use for it, so they decided fossil fuels and gasoline and high-powered cars would be a good way to sell some lead. The first vice president of the Ethel Corporation said, "The development of tetraethyl lead is an apparent gift of God." So even as concerns grew, ads were used to reinforce lead as a boon to children and linked lead paint to cleanliness, durability, and safety. So as the government sought to learn a bit more about the health effects of lead, and they went to the Bureau of Mines. And turns out that GM basically paid the Bureau of Mines to come up with the results that they wanted. So the owner of a small car company asked, "May I be pardoned if I ask you frankly now, does the burden of mines exist for the benefit of Ford, GM Corp., and Standard Oil Company of New Jersey and other oil companies? Or, and to the distribution of ethyl lead dopes? Or is the Bureau supposed to be part of the public benefit and in protection of health and life?" So as the government proceeded, they adopted one of the very first environmental laws that you might think of that they adopted was the Federal Insecticide and Rodent Protection Act. And this was adopted in 1947, but it was not designed to assure that pesticides were safe. It was designed to assure farmers that the products would be sufficiently lethal to kill weeds and insects. So it included only the very scantest oversight of chemical companies. And so when this was revisited, even in 1972, Congress decided that rather than having to prove products were safe, that the government should have to prove that products were dangerous, and that the EPA would not be able to take any action unless it could prove an unreasonable risk to man or the environment, taking into account the economic, social, and environmental costs and benefits of the use of any pesticide. So as you can imagine, that was a pretty difficult burden for the EPA, then as now, with very little funding and staffing and the like. And so then we turn one of the things that was tried to regulate under another environmental law, the Toxic Substance Control Act, which again puts the burden on the government to prove things are unsafe. And the government has to basically rely solely on research submitted by the manufacturers. One of the chemicals that they were trying to regulate was asbestos, which they still continue to have difficulty actually regulating, even though John Manville and other companies have been put out of business. But a Boston University professor who was a witness in the asbestos litigation, described the asbestos industry's approach as follows, and it sort of sounds a lot like there's been never a proven incident of drinking water contamination from an instance of hydraulic fracturing. So the industry starts out with, asbestos does not hurt your health. Okay, it does hurt your health, but it doesn't cause cancer. Okay, asbestos can cause cancer, but not our kind of asbestos. Okay, our kind of asbestos can cause cancer, but not the kind this person got. Okay, our kind of asbestos can cause cancer, and it is the kind of cancer this person got, but not at the doses that this person was exposed to. Okay, asbestos does cause cancer, and at this dosage, but this person got his disease from something else, like smoking. Okay, he was exposed to our asbestos, it did cause his cancer, but we didn't know about the danger when we exposed him. Okay, we knew about the danger when we exposed him, but the statute of limitations has run out. Okay, the statute of limitations hasn't run out, but if we're guilty, we'll go out of business and everyone will be worse off. Okay, we'll agree we'll go out of business, but only if you let us keep the part of our company intact, and only if you agree to limit our liability for the harms we have caused. So, some sort of pretty similar takes on sort of where the burden is and what you wind up proving and how the ball keeps moving. In a magazine for corporate attorneys, Joseph Thomas, a Cincinnati lawyer, explains this strategy in the context of formaldehyde litigation. And he writes, formaldehyde litigation presents a situation where every stone should be unturned in looking into a victim's background. Because formaldehyde is so common, he suggests looking for other causes of other possible sources of exposure, including this following catalog: a survey of the living and work environments of the plaintiff's entire life, an evaluation of his exposure to cigarette smoke, an evaluation of her personal hobbies, such as cooking, gardening, and photography. If a thorough history is established, the alternative sources can be found. Also, he points out, there may be a history of anxiety, depression, or psychosomatic disorders that can account for a number of the plaintiff's complaints. So these are, some of the same things that we continue to run into here with sort of the blame the victim mentality. And then you wonder sort of, well, what about science? And will we be able to rely on sort of some sort of objective science to come to the rescue? The editor of the New England Journal of Medicine writes that when the boundaries between industry and academic medicine have become as blurred as they are now, the business goals of industry influence the missions of the medical schools in many ways. The effects of powerful constituencies to manipulate researchers and scientific organizations may constrain vital research on health risks. A recent study of corporate funding of academic research revealed that more than half of the university scientists who received grants from drugs and biotechnology companies admitted the donor expected to exert influence over their work, and that in many cases, in public health science, politics is winning over research because of the carefully executed strategy of special interest groups. So this isn't really anything new. And when we look at the natural gas industry and sort of the regulatory system that exists now, there's sort of a number of federal statutes that are regulating this, as well as some at the state, and then the possibility of some local control. So at the federal level, and this could be an entire semester-long legal course, there's the Safe Drinking Water Act, the Clean Water Act, the Clean Air Act, the Toxic Substance Control Act, FERPA, as I mentioned, the Rodent Act, RCRA, the Resource Conservation and Recovery Act, CERCLA, which the Superfund law, Right to Know, NEPA, the act that the National Environmental Protection Act, the national sort of version of SEEKR, and FERC. And almost all of these, and then you have the DEC and the PSC, the Public Safety Commission at the state level. And almost all of these environmental laws are focused on, rather than looking at any big picture, on a particular way that a pollutant might get emitted. Will it get emitted into water? Will it get emitted into air? Will it be injected into groundwater? And how do we deal with sort of these pollutants once they're in our atmosphere or in our soil or in the water, versus sort of trying to take a step back and look at how pollutants are generated in society. Instead, there's much more of a focus on disposal, and it's very segmented and results in this being a very complicated area to understand. But the natural gas industry has been hard at work for a long time. Unfortunately, we can't blame just Dick Cheney in 2005. Many of the exemptions from the natural gas industry date back to the formation of the statutes themselves in the 1970s, whereby you can take the definition of hazardous waste and it will say, all these things are hazardous waste, semicolon, except when used in natural gas exploration and production. So we're working in a system that is both fragmented and provides a number of exemptions for the gas industry, a whole plethora, unfortunately, and with a state government where many have asked recently whether our DEC is almost like the Bureau of Mines was back in 1925, and who are they really working for? So, which has led a number of people, including our group, to conclude that the real place that one might be able to take some action here is on the local level, which raises questions of preemption. And Mary Jo's going to talk more specifically about the preemption in the environmental conservation law that most people point to as precluding local, any sort of local regulation having any impact at all on the natural gas industry. As I believe Mary Jo's concluded, we've concluded that that preemption provision only excludes local governments from acting to actually regulate the operation or process of a natural gas facility, but that zoning and other laws that have their basis in land use and not in actually trying to regulate a specific industry could be allowed. So some of the things that we think are sort of some bright spots are the ability of communities to control solid waste. There is a provision in the environmental conservation law that communities are allowed to decide whether they want solid waste disposals in their communities, and if they do, how it's going to be handled. Hazardous waste can be a more difficult area for local communities to exercise control over, but luckily, the waste from natural gas facilities is considered to be solid waste. So this is a way in which there's the potential for local communities to use a portion of the definition of solid waste to specifically identify this and other solid waste that they don't want disposed of in their community, and to prohibit that, and or potentially to prohibit the generation of certain kinds of solid waste in their communities. The Underground Injection Control Act, which is how they regulate injection wells, which is part of the Safe Drinking Water Act, all of those acts, as we've learned, well, A, there's the Halliburton loophole, but B, they only protect public water supplies, which serve 25 people or more, 15 people or more with 25 connections, but certainly not rural water supplies. Well, local governments have the right then, if the federal government is not going to regulate and can't for various federal limitations on interstate commerce and the like, if these water supply systems are too small for the federal government to regulate, it's a matter of local concern. A local government decides that they want to regulate this. As part of the implementation of the Safe Drinking Water Act and Underground Injection Control Act, the state is not the one that administers those programs. They haven't taken over. So the locality would be implementing a federal program, thereby not preempted by any sort of state program. So a locality can restrict not only injection wells, but also potentially could define injection wells to include, as was reversed with the Halliburton loophole, the injection of all of these wastes that stay underground, that they're discarding hazard or solid waste when they inject these various chemical slurries underground, and leave 80–90% of it behind. When the gas companies first sought exemption from the Safe Drinking Water Act, their convenient rationale at the time was that it all came back. Nothing was disposed of underground. It was injected and it returned to the surface. And those were the sort of numbers we heard for some period of time. 80–90% of the water came back. It didn't stay underground. When people started to complain, this water that comes back up, it's not water at all. It's radioactive, it has heavy metals in it, it's got all these chemicals, it's been baked and pressurized underground, and you bring it back up. This is tremendously toxic waste. Oh, not that much comes up. 80–90% of it stays in the ground. So now that that's staying in the ground, and that's their position, then the rationale for not covering these injection facilities as underground injection control has disappeared, because the waste is staying underground. So we think there are some interesting ways like that there are ways using, part of what I believe Mary Jo's going to talk about is road protection agreements and the like. And everyone acknowledges that there's just this tremendously heavy traffic generated by these uses. Particularly natural gas, but sort of a number of these water withdrawal facilities, wastewater treatment plants, et cetera, terminal staging facilities that they might have. Well, one way that a community can use zoning is to reduce congestion and traffic in the streets. So you may not be able to regulate traffic as it travels from one place to another in interstate commerce, but you can prohibit uses in your town using zoning based on the fact that they generate tremendous amounts of traffic, which is not an area where the DEC is trying to regulate. The DEC will say they're not regulating based on traffic, that's the DOT's concern, not a matter for the DEC. They're not really going to consider traffic. Terrific. The locality can consider the traffic impact and decide that uses that generate, land uses that generate that sort of traffic can be prohibited. So that's sort of a brief overview on how, and all of this in New York is complicated. It requires careful drafting, looking at the zoning and local ordinances in each town, reflecting these sort of, and for any sort of local law to be very carefully tied to protection of the health, safety, and welfare, looking at both regional and local land use, existing laws, and again, the comprehensive plan. But in communities that have a desire to try to limit some of what's happening in their communities, we believe that there are some significant ways that communities can effectively just say no, and that it's not all as hopeless as it might seem, and that we might be able to use a number of sort of these exemptions and the like that industry has fought for at the larger level to be able to implement some controls at the local level. So thank you, and I think questions will probably be more interesting than me sort of ranting away, so I will turn it over to Mary Jo, and thank you very much.
My name is Mary Jo Long. I'm going to review some legal tools that are available to local governments with respect to gas drilling. As citizens express increasing concern about gas drilling, they have been asking local governments to do something. Most local government officials are saying that there is nothing they can do. However, there are a range of legal tools, from road laws, which simply seek to ensure that the cost of road repairs from gas drilling will not be borne by the taxpayer, to more extensive laws restricting the locations of wells through zoning. Some local governments, when pushed by their constituents, are reviewing their noise laws, their building codes, their subdivision regulations, their community plans, and their zoning laws to determine how their laws are affected by the separate regulation by the Department of Environmental Conservation and by the Public Service Commission. Citizens are asking their local governments about home rule and how that intersects with gas drilling. As a general principle, local governments have far more power and more legal tools available to them than they think they have. If and when your local government wants to be assertive of their right to have a say about the gas industry moving into their community, there will be municipal attorneys helping them to exercise those rights. But local government will only assert their rights if their constituents are insisting on it. I think it's eminently reasonable that local governments, local elected officials, be involved and make specific rules, regulations, or laws for activities such as gas drilling, gas pipeline excavation, storage and disposal of gas and waste products from gas drilling in their jurisdiction. And that's because local officials and their local constituents live with the impact of gas drilling, or will, and its industrial impacts on their land. For example, a couple of years ago, the DEC granted a permit to drill a gas well in a floodplain in a town near here. And the town supervisor called the DEC and said, wait a minute, you guys, that well permit you granted is in a floodplain, and he listed the number of years that that area had been flooded. But the DEC basically brushed him off. But he knew the details and the specifics of that area. And I remember, and many of us may remember, the flood of June 2006. My town is on the Susquehanna River. And I saw the gooey sludge that, when the floodwaters receded, that coated the land. And we were downstream from the Amphenol plant in Sydney. Local officials who know their own geography and their own geology and their area have something very specific to give to the decisions about what works in our particular part of the country. And so, and I think that each locality knows their particular vulnerabilities, and that we should be involved, and the local officials should be involved, because we can't vote the DEC out of office. They're not subject to elections. But if we can have some control over this, we can do it through our elected officials who either will do what their constituents want, or they can be voted out of office. After all, that's what real democracy is about. And leaving it and relying on agencies at the state level, such as the DEC, to try to protect us is not adequate. Now, you need to know a little bit about my background and experience. I didn't tell you at first. I have been an attorney since 1977. I graduated from New York University Law School, and I taught law, first at Cleveland Marshall Law School and then at Case Western Reserve School of Law, and eventually became the director of their clinical law program. Then I also have taught undergraduate college-level law courses while I was joining a law firm in Albany, New York. I haven't taught now since about 1985, unless you count my being a legal advisor for the Afton mock trial team. Instead, when I moved to Afton in 1990, I continued my private law practice. And one of the clients that I had fairly on after moving to Afton was the village of Afton. They asked me to be the village attorney, and so I started learning municipal law and had the experience of being a village attorney. And I know that one of the things that village attorneys, certainly that I did, and I think all of them, have this very strong impulse to avoid getting sued. Just, you know, that's a major goal. Keep your village from getting sued. And I think that that may sometimes conflict with some of the issues that will be coming up in terms of being a municipal attorney, whether it's the town or the county or the village. But I know that experience. Now, the other thing that I did is that in 2005, I ran for the Afton Town Board. And I was elected. And one of the very first issues that came up in those days was the NYRE issue, New York Regional Interconnect. Some of you may remember that. And because I was an attorney, I took a leading role in my town to make sure that we had a moratorium. I learned about moratorium law, and we had a moratorium in Afton as well as many of the other towns through Chenango County, and we renewed it every year until the issue went away. Then I was re-elected to another 4-year term in 2009, and most recently in December of last year, just a little more than a month ago, my town of Afton passed a concentrated heavy traffic road protection law. And to be clear, because I think sometimes it's a little confusing, I wasn't the town attorney. We have an attorney. I was on the town board. So first I want to talk about the legal tools are ones that clearly the local government has the legal authority to do, and that is a good thing to do, whether you're in favor of gas drilling, whether you're undecided, or whether you're opposed to gas drilling. And that deals with the road protection laws. There is a statute at Article 23 of the Environmental Conservation Law which gives the Department of Environmental Conservation, DEC, the power to regulate oil, gas, and solution mining. What it says is the state oil, gas, and solution mining regulatory program supersedes all local laws or ordinances relating to the regulation of oil, gas, and solution mining industries, but shall not supersede local government jurisdiction over local roads or the right of local governments under the real property tax law. So we're going to talk about this statute some more later, but right now I mention it because even though the certain rights are superseded by state regulation, they specifically point out that local governments shall continue to have control over their local roads. As I learned about gas drilling several years ago, I became aware of the impact on town roads. And I recommended that the town of Afton have a road preservation law. One of the first comments that came up about this was there was actually some skepticism as to whether gas drilling damaged local roads. One guest at a meeting suggested that all that heavy weight would compact the roads and make them better. But pretty quickly, most people recognized if they did a little bit of research, they figured out that that was not the case. And in fact, it's particularly hard on local roads because interstate highways and state highways are built to handle a lot heavier traffic and a lot more frequency, a lot more traffic concentration than local roads. So as I looked at other communities and did research, it really had a devastating effect sometimes on local roads and was very expensive. We wanted to make sure that the taxpayer would not be left to pay for the cost of repairing the roads. And Afton, we have a lot of leased land, so we felt that this was going to be happening. The process actually took longer than I expected because many different concerns were raised throughout the drafting and the revising and understanding the law. We ended up in the town of Afton going through 4 drafts of the law before we passed it. And I'm going to go through some of those conversations because it is something I recommend for all the communities to have. We're going to talk later, and Helen has mentioned it, that there are certainly is the possibility of doing zoning that would limit and restrict gas drilling. But even if you have those restrictions, those trucks might be going through your town to get to the next town where there are not those restrictions. So I think it's a good idea all the way around. The concerns that were brought up about it were, first one was that we were going to get sued for discrimination, that we were discriminating against gas drilling companies. I have heard, but have not confirmed, that there is at least one town that has passed a road protection law that just specifies it applies only to gas drilling. That is not what Afton did. We passed a general law. But just so you understand the argument, the 14th Amendment, which was passed to give former slaves citizenship status, said that any person born or naturalized in the United States is a citizen and has rights, privileges, and immunities, rights of due process, and the right to the equal protection of the law. Through a line of lawsuits, courts have given corporations personhood status and says we can't discriminate against them unless there's a reasonable basis for doing so. That's what the 14th Amendment to the U.S. Constitution requires, a reasonable basis for treating some different than others. I actually think it's an interesting point that the federal government treats oil and gas drilling different through exempting them from environmental laws that the rest of us have to obey. And so that is a form of discrimination, but we didn't want to do it that way. We were concerned about being sued, and so the law that we passed is does not specify and only deal with gas drilling. Our law applies to concentrated heavy vehicle traffic, regardless of the type of construction or development. In other words, a general law. We set a threshold to and from a single project site by a vehicle or vehicles having a gross weight of 60,000 pounds or more that travel over a town road or roads more than 50 vehicle trips per day for more than 4 consecutive days, regardless of whether the vehicle trips are a single vehicle traveling multiple times or multiple vehicles traveling 1 or more times. So it is not something that specifies that it's gas drilling, although clearly if you do the research you'll know that it will apply to the kind of gas drilling that we don't have yet in Chenango County or New York State, the horizontal high volume hydrofracking in shale rock. Several of our town board members preferred a voluntary road use agreement. They wanted just a contract, a road use agreement with the companies that would be coming in. It was suggested that we didn't need a law because gas companies would be good corporate citizens and that they would want to do what's right. Renew, which is the biggest leaser in Chenango County, even sent us a letter saying that they would repair any damage to roads that were from their fault, but not any ordinary wear and tear. But of course, Nornu isn't the only gas corporation that's doing leasing and would be doing drilling. And you cannot force a corporation or an individual to sign an agreement. That's the definition of an agreement or a contract. It's voluntarily signed. If you've been forced into it, it's not an agreement. It's not a contract. So we talked about that for quite a long time. We had to bring our town attorney in. We questioned him. People really had these serious concerns. We got past that hurdle by having the law require a permit for concentrated heavy traffic with monetary assurance funds, and provided an option that a project could negotiate a road use agreement. It had to conform to the standards in the law, but it allowed for additional terms that the parties might want to agree on. Routes especially, I think, was one that we talked about. The gravel haulers came to us. They were concerned. They had read a draft of the law, and they were concerned that they were going to have to get a permit every time they drove gravel to a gas well or a project development site. And that was not our intent, so we had the law revised again to make it clear that that they didn't have to apply for the permit for each trip they made, but that rather that it was the project sponsor, the developer or project contractor who was responsible to get the permit that would apply to all of the road traffic. And that satisfied the gravel haulers. One of the other concerns that you might hear if you do this is, well, how are we going to enforce this law? We don't have a police force in the town of Afton. But it was pointed out that, what happens with our animal control problems are a neighbor calls the complaint in. And if we're going to have troubles on our roads, neighbors are going to call those complaints in. So we got past that hurdle. And I think kind of the last one was, that we're going to get sued, and it's going to be too expensive. We can't afford to be sued. But first of all, the cost of the roads repairs are going to be more than a lawsuit. And besides, the environmental conservation law specifically says towns have the right to do road loss. So it's really worrying about something that isn't likely to happen. And we finally passed the law by a 3-2 vote. And I felt great relief. Thank you. So I hope if you do this in your own communities or towns, it won't take as long, but you should know that, in fact, the law became better because of all of the involvement and questions and concerns and input that people had. It seemed like a long, hard road to hoe, but it is a better law because of the concerns and questions and the process that we went through, in my opinion. So what about other powers that local governments have that are not specifically set forth as not being precluded? Lawyers call this the question of the superseding state laws, or preclusion is another word that the attorneys tend to use. Municipal attorneys like Helen and there's a Michelle Kennedy over in Otsego County, and there's some lawyers in Albany who work for the New York State Association of Towns. Municipal attorneys are beginning to point out that the scope of the municipality's ability to exercise home rule authority over natural gas drilling activity is not limited to road laws. Zoning is not a regulation of gas drilling. It is a regulation of land use, which is a power granted under home rule provisions. And home rule authority in New York State is in both the New York Constitution and in New York statutory law. So now we're going to go back to that environmental conservation law that I mentioned. I think I even read it earlier, EC, that's Environmental Conservation Law 23-1 303 subsection 2 says oil, gas, and solution mining, including, well, it doesn't say this, but that includes the development of Marcellus and Utica shale play, is regulated through this Article 23 of the Environmental Conservation Law. And EC 23-0303 subsection 2 was amended in 1981, and a provision was added which pro-gas drilling entities have used to claim that this amendment precludes local governments from having any say in gas drilling. What the statute actually says, as amended, was that the state's oil, gas, and solution mining regulatory program supersedes all local laws or ordinances relating to the regulation of oil, gas, and solution mining industries. Those words are important. Relating to the regulation of the oil, gas, and solution mining industries. And then, of course, it goes on to say what I was mentioning about the road laws, but shall not supersede local government jurisdiction over local roads or the right of local governments under real property tax law. That's what the statute says. The gas industry and others that have a financial interest in gas drilling say that that means that local government zoning power is precluded. One has to remember this is an important point that I think of because of my teaching law and the kind of law that I taught, which was the practice of law. I took students in their last year of law school and had them have clients and prepare complaints and go to court and sometimes even do trials, and the skill, the craft of lawyering. One of the things that we teach lawyers to do is to speak in the interests of their clients. So I have heard lawyers say, some lawyers say, when a town wanted to have a moratorium or wanted to enforce zoning laws that zoned out industry, oh, you can't do that about gas drilling. Oh, you can't do that. But a lawyer is representing his or her client. And if the client's interest is to have no laws that interfere with gas drilling, or if the client's interest is to have gas drilling as soon as possible, such as a lawyer representing a landowner coalition, that lawyer is required to be an advocate for his or her client. And they don't say, it's my client's position that you shouldn't or can't do that. They just say, oh, you can't do that. But they're advocating for their client when they say that. Municipal lawyers municipal law attorneys are beginning to have begun the research and pointed out the narrowness of the words relating to the regulation. And I'll read it again. The regulatory program for gas, run by the DEC, supersedes all local laws or ordinances relating to the regulation of oil, gas, and solution mining industries. So clearly, the Environmental Conservation Law supersedes all laws relating to that regulation of the oil, gas, and solution mining. There are no appellate decisions interpreting the reach of those words. But there are appellate decisions interpreting similar language that supports the right of local governments to continue to do land use planning, such as zoning. Those decisions review a similar provision in the Mined Land Reclamation Law, which I'm going to walk you through here in a minute. But first I want to also talk a little bit about home rule. New York is a home rule state. Article 9 of the New York State Constitution provides broad authority to local governments to enact local laws related to their property, affairs, or government, and for the protection, order, I'm reading here because I can't remember all this, protection, order, conduct, safety, health, and well-being of persons or property therein. The New York Constitution also directed that the legislature enact a statute of local governments. And in that statute of local governments, which they did in 1965, New York specifically conferred to cities, towns, and villages the power to adopt, amend, and repeal zoning ordinances. Article 9, subsection 2, subsection B, subsection 1 of the New York State Constitution requires that any legislation that would diminish or impair a power conferred by the statute of local government be reenacted during a subsequent term of the legislature. This means that since Home Rule was conferred by the statute of governments under the authority of the New York Constitution, any amendment to a law that diminished rights should pass twice. And certainly the amendment to the Environmental Conservation Law, this one that I was reading about superseding local governments, turns out was not passed twice. So when when some municipal attorneys brought that one up, I thought, wow, that's pretty powerful, and perhaps it will turn out to be pretty powerful. What I've also subsequently learned is that the courts in New York have treated this two-vote requirement with a regrettable degree of skepticism and disregard. Where this has been raised in some other cases, they have not always been successful. So I can't say to you, oh yes, this is going to definitely succeed. But it's a good argument, and it will be followed. I'm sure that this argument will be raised when and if it comes to an interpretation of that provision of the law about superseding all powers of the local government. The only reported decision that addressed this section of the Environmental Conservation Law was an Erie County Supreme Court decision called Envirogas versus Town of Keatone. I think that's how it's pronounced. It invalidated the imposition of a $2,500 compliance bond and a $25 permit fee for any person wanting to construct an oil or natural gas well. So you see here, it names specifically an oil and gas well. And that brings in that discrimination, that concern about being sued for discrimination, which I mentioned earlier. Its words specifically targeted the oil and gas industry with a specific regulation. So the court said they knocked that down. But at the same time, the court did accurately set forth the rules about what supersedes or preempts local law. The mere fact, this is a quote from the court, the mere fact that a state regulates a certain area of business does not automatically preempt all local legislation which applies to that enterprise. But where a state law expressly states that its purpose is to supersede all local ordinances, then the local government is precluded from legislating on the same subject matter. And the decision acknowledges that there was, qualifying language of the relating to the regulation, and that might be relevant for determining the scope of other town laws and whether they were superseded or not by the DEC's authority to regulate gas drilling. Because of constitutional home rule requirements, the powers conferred upon local governments are to be liberally construed. The express preemption language should not be expanded because there is an existing regulatory system. It should be construed to preempt laws relating to the regulation of the gas industry only. And the legislative history of that amendment to the law certainly does not indicate that it was the intention of the state legislature to preempt all powers of local government. I mean, they specifically mentioned road preservation and taxes, but there is no legislative history that could be cited to say it was looking at the home rule powers and the police powers as well. So towns can't specifically regulate gas drilling. And so that you understand what I mean by that, for example, a town couldn't pass a law saying the concrete casing around the well has to be 6.5 inches or more, or it has to be of a certain kind of concrete, or the daily operation of gas drilling. That requires an expertise that we would wish that the DEC has. We hope that they have. That's to be seen, but that's not what towns are allowed to do under this interpretation. However, towns can exercise their zoning powers in that regulation of land use is not the regulation of gas industry. There's a similar provision in the Mine Land Reclamation Law, which has been interpreted by higher courts to not preempt local land use regulations such as zoning, despite an incidental impact on, in that case, gravel and sand mining. This Mine Land Reclamation Law is also in the Environmental Conservation Law. It's even in the same article. It's in Article 23. It's just at Title 27 instead of Title 23. And it has very similar language, suppression language, that is. It's about superseding local laws. The Mine Land Reclamation Law was passed in 1974 with a similar language, which says that the DEC's regulation of sand and gravel mining supersedes all local laws relating to the extractive mining industry. And it also, like the one on gas drilling, then reserves some town rights with respect to imposing stricter standards for the reclamation of land. So in other words, you do the gravel mining, the standards are set by DEC, but the law said, you know, in terms of reclamation, reclaiming the land afterwards, you can have higher standards. In Frew Run, F-R-E-W, Frew Run Gravel Products versus the Town of Carroll, which is at 71 New York 2nd, page 126. This is a 1987 case. The New York Court of Appeals upheld the right of local governments to zone out gravel mining, even though the industry is regulated by the DEC. The town of Carroll had passed a zoning law that prohibited a sand and gravel mine in a specific zone. They had several zones. They prohibited it in zone AR-2 district. And the lower court had actually thrown out that law. They had invalidated it. The town, fortunately, appealed, and at the appellate level, the appellate division reversed the lower court, and then the gravel company appealed, and that went to the Court of Appeals, which is the highest court in the state of New York, and the Court of Appeals upheld the zoning law of the town of Carroll. They agreed with the appellate division, and they referred to the plain meaning of the term relating to the extractive mining industry. The town's zoning ordinance related not to the extractive mining industry, but to an entirely different subject matter and purpose, that is, regulating the location, construction, and use of buildings, structures, and use of land in the town. The court said, in this general regulation of land use, the zoning ordinance inevitably exerts an incidental control over any of the particular uses or businesses which, like sand and gravel operations, may be allowed in some districts but not in others. But this incidental control resulting from the municipality's exercise of their right to regulate land use through zoning is not the type of regulatory enactment related to the extractive mining industry which the legislature could have envisioned as being within the prohibition of the statute. So it was a long sentence that Court of Appeals wrote, but it basically said having regulations or laws about zoning, even if it affects a particular industry or business, is allowed when it's part of the reasonably passed laws for how that town wants to zone activities in different areas of the town, or to zone it completely out of the town. Subsequently, the Mine Land Reclamation Act was amended specifically to say that zoning laws were not preempted. And then there was another case, the Gernat Asphalt Products versus the town of Sardinia, which is a 1996 case. In that one, the Court of Appeals, again, the highest court in the state of New York, looked at the town of Sardinia's zoning law that eliminated mining, this is sand and gravel mining, as a permitted use in all zoning districts in the town. They had already had gravel mining in the town of Sardinia, and they decided to exclude it. And the Court of Appeals rejected the argument that the mine land reclamation law preempted that local government's authority to determine that mining should not be a permitted use of land in the town. The court said, quote, "A municipality is not obliged to permit the exploitation of any and all natural resources within the town as a permitted use if limiting that use is a reasonable exercise of the police power to prevent damage to the rights of others and to promote the interests of the community as a whole," unquote. And the court did not rely on the amendment language in doing that. It found that a zoning ordinance that regulates land use generally, not just picking on one, but land use generally, is distinguishable from an ordinance that specifically regulates mining activities. There's even a case I saw where private plaintiffs were granted an injunction against a gravel mining company that was required to get a permit under their town law, but the town hadn't been trying to enforce it. And so private citizens were able to get an injunction under town law, section 268, to enforce the law that the town had passed. This distinction of regulating the industry or regulating land use is one that Pennsylvania courts have also recognized, and we know they've had a lot of experience with gas drilling. There are a couple of cases that the highest court in the state of Pennsylvania has decided about a year ago, and they decided them basically simultaneously. One of them invalidated a township law a zoning law that sought to regulate location, design, and construction of access roads, wellheads, and requirements for site access and restoration. So they invalidated that law. They felt that was regulating the industry. But in Huntley and Huntley versus Borough of Oakmont, the highest court in Pennsylvania upheld a municipality where it prohibited, the court held that the municipality was not prohibited from regulating which types of land uses are appropriate within their municipal boundaries, and upheld Oakmont's decision to zone out natural gas well drilling operations. So this is a logic that the state of New York, we don't have it in high appellate decisions regarding gas mining. We only have language in very similar statutes regarding mine land reclamation. That logic, though, has been followed in Pennsylvania and perhaps other states. That I can't say. So there's certainly good arguments that local governments, through zoning powers, to limit land use in gas drilling to certain areas or to exclude them altogether. It can do this through zoning on location rather than operation. Jernat, one of the cases I mentioned, talked about police power, and I thought we should know a little bit about police power in talking about local government. Police power is the power to regulate persons and property for the purpose of securing the public health, safety, welfare, comfort, peace, and prosperity of the municipality and its inhabitants. The police power is as old as the organizations of towns. Some courts, in fact, have said that when a state imparts the status of being a town or a county or a village or a city, that it imparts the police power by the implicit in the grant to govern. It's implicit that the police power is included. So the scope of municipal police power is given a broad construction. It can include prevention, suppression, abatement of public nuisances, such as street nuisances and air pollution. It covers the preservation of public peace and tranquility, and it can also include the protection of public health in connection with the regulation of sanitation, disposal of waste products, protection of the public from the bad effects of industrial and commercial developments, and the proper growth of municipality through zoning. There are specific grants of police power to local governments in the New York State Constitution, in the municipal home rule law, in the town law, in the general city law, and in the village law. So that's something we also have as a power. Now, Helen mentioned a few other kinds of powers that local governments have, and I'm going to just add a few. One of them that really comes out of the police power but is specific in New York public health law at Article 13 is that local governments can have local boards of health or a health officer if they don't want to have a whole board. And that often happens more generally at the county level, but the law allows other municipal governments to do the same. And the public health law gives power to examine, investigate, and abate a nuisance. That article gives broad powers to investigate and activities that may be harmful to the public's health, and where such a public health hazard is found to exist, that's the definition of a nuisance, to order the owner or operator who caused the nuisance to clean it up and abate it. And if the owner or operator refuses, the health board or health officer can go in, clean it up, and charge the owner or operator the cost of the cleanup. The law also says that that the health department or the health board has to investigate complaints that that would cause danger or injury to health within their district. And they can even get temporary restraining orders in certain situations by having to go to court, of course. So that's one. Local governments can have the authority with regard to stormwater runoff regulations for developments and constructions that disturb land greater than 5 acres. These are often administered by local code officers already, and that's something, if your town hasn't taken that up, there's a process for becoming the responsible party for enforcing stormwater runoff regulations. And in fact, many urban communities have adopted their own stormwater runoff regulations, which govern construction sites as well as other places that might contribute to stormwater runoff pollution. Another topic that I've seen talked about are seismic testing laws. There are quite a few concerns that have happened locally with seismic testing, and there have been some suggestions of laws that require the permission of the adjacent landowners and things of that sort. So that's another one. Again, that's not preempted. That's not regulation of the gas industry. Those seismic tests are done, although they may be done for gas drilling, they are done quite separately and not contiguous to the operation of gas drilling. Towns and villages have the power to enact local site plan review regardless of whether or not they have zoning regulations in force. So these should be examined to see if gas drilling activities would require sketch plans, preliminary site plans, to see if they meet various local requirements. And before approval of a site plan, there usually is a public hearing where the community has input into the plan requirements. And finally, those local governments who do have water treatment plans should make sure that their plant operators have the authority to limit use of local facilities if the effluent being brought in won't meet the existing discharge standards. Where there are not regulations, local governments can step in, and especially, of course, if it falls under that police power authority. The most recent one I've been hearing quite a lot about is that the Public Service Commission, which regulates gas pipelines, does not have authority for any pipelines less than 125 pounds per square inch, which are most of the gathering lines. And there's, I know, quite a bit of interest in that. I don't have any specifics to say about what that is, but apparently local governments do have the right to step in there and start defining the standards by which this industry would have to, what they would have to follow with regard to that size of pipelines. So is any local government doing this? Local governments are only going to respond if they get pressure from their constituents. Some towns In Otsego County, I know of some in Sullivan County and Tompkins County, there may be others, are reviewing their comprehensive plans and their local zoning laws. Their citizens are pushing those town governments to enforce these zoning laws if they're already on the books. If those zoning laws zone out industry, that would apply to the gas industry. Many towns have zoned out industry, or at least limited to certain areas. They have residential areas, they have agricultural areas. There are some towns in the area that have zoned out industry. And so there really is a good argument that those towns, their zoning laws will apply, because they're not regulating the gas industry, they're regulating land use. Where there are no such restrictions, some constituents are pushing their towns to review and pass such restrictions because they want to preserve the rural nature of their communities. One of the problems I see for little towns like Afton and some of the little towns in Chenango County is that some of them, perhaps many of them, don't have a comprehensive plan and may not have any zoning. And if the gas companies end up avoiding towns with restrictions on gas wells, such as towns with zoning laws that you can only have a gas well in an industrial zone, and maybe they don't even have any industrial zones at all, those gas companies may go to the least regulated towns to be able to minimize the need to pay for the costs and uncertainties of the more regulated communities. The least regulated towns may get the most intensive gas drilling. And so that, that's a hard thing to think about, but it's certainly something I have heard Otsego County communities articulating, that if they do these laws, gas drilling will not want to go there. And that's what they want, and so that leaves them perhaps going to some of us who are not so regulated. So I'm talking about different kinds of legal tools, and I think one other than that I would just mention to you, it's not really happening in New York State, although I guess there's some evidence, some rumors in Buffalo it might. But in Pennsylvania, several townships have tried to regulate various industrial practices, not just gas drilling, sewage sludge spreading, other kinds of things, and have done it in a broader and more radical manner. They have been frustrated with the permitting agencies and the imposition of a type of economic development that a community doesn't want. These townships in Pennsylvania have passed laws even though they've been told that it conflicts with state law. The Pittsburgh City Council in November of 2010 passed a ban of natural gas extraction within its boundaries. But the ordinance isn't just a ban. The law establishes a new Bill of Rights for Pittsburgh residents, including a right to water, rights for ecosystems and nature. Pittsburgh then proceeds to ban those activities, including natural gas extraction, which violate those rights. And it goes even further, in that it challenges the dominant legal framework where corporations have come to have more rights than communities in which they do business. There have been similar ordinances passed in other townships in Pennsylvania. They challenge the notion that communities should not be able to interfere with profit-making opportunities, even if they will cost the public more than the public wants to pay. They frontally and directly challenge layers of pro-corporate law which have removed the right of community self-government. It is a kind of disobedience that makes many people uncomfortable, especially those who will make money off of gas drilling. But defiance and disobedience are not out of the question. I'm old enough to remember Southern segregationists enforcing racial segregation laws against black people riding in the front of the bus or sitting at public lunch counters. And change happened. The dominant legal framework, even on that, has changed and been overturned. And closer to home, when the federal government told New York State that the state had to take responsibility for having places to dump so-called low-level nuclear waste, Governor Mario Cuomo went about doing that by appointing a siting commission. We were told that there was nothing we could do except hope that the site wasn't in our backyard. When Allegheny County had turned up with 3 of the last possible 5 sites for the dump, they had done a lot of preparation to get ready for it because they thought they might be the site. They had lawsuits going. There was a whole battery of tools they used, and lawsuits was one of those. But they also tried passive resistance by showing up in large numbers and blocking the individuals from the siting commission from entering the properties that were the potential sites. On one occasion, several elderly, well-respected citizens of the community chained themselves to a bridge to block the siting commission from getting to one of the sites. Governor Mario Cuomo backed off, and eventually the U.S. Supreme Court said that states could not be forced to take responsibility for this nuclear waste. So disobedience and defiance should not be discounted completely. We have a long way to get to that point, perhaps, but I wanted to lay out all the different legal tools that I was aware of. Change can happen. Historically, there have been tensions over the powers of government to regulate corporations, like gas corporations. There was a time in New York State when corporations, by law, could only exist for a limited number of years, or only to do a specific task, like build the Erie Canal. And they were not allowed to own another corporation. Boy, doesn't that tell you how times have changed? It's inconceivable now, isn't it? Maybe. I can conceive of it, I guess. Similarly, New York State used to allow people to own slaves, but that changed. The law can be changed. Citizens could demand that the laws be changed to allow more government control over corporate entities, including gas drilling. The federal and state government, though, have endorsed the decision to develop natural gas in the United States. The reasons, I think, are short-term economic and political. The gas industry is perceived as too big to be contradicted and has too much money to stop. The state and federal governments are too corrupt to do other than the industry's bidding. When I first started hearing about the gas industry moving into our area, speakers were brought in from Colorado and Wyoming, where industrial scale gas, hard shale gas drilling had started years before. And the speaker said, gas drilling is coming. There is nothing you can do to stop it, but start getting your ducks in line, do some regulation, and maybe you can get the gas companies to agree to some level of mitigation. If local government doesn't claim their rights, then local government will be ignored and rolled over. I think town governments will actually be the leading edge in any resistance or effort to either prevent or minimize the impact of gas drilling in our area, because they are the more affected by their constituents than state and federal governments, who are far more influenced by big money, using usually corporate money. We the people have a better chance of influencing local governments through local elections and through local pressure. Most towns in Chenango and Broome County are reluctant to do anything, and they need political pressure from local constituents before they will act. How far they will go depends on us. Thank you.
I'll tell you the question I won't ask Mary Jo. If corporations are persons, and if slavery is no longer allowed in this country, how can one corporation, which is a person, own another corporation, which is a person? So apparently laws have contradictions in them. But I would ask Mary Jo and Helen also, because I know Helen is very active in helping municipalities. The other day at the Natural Gas Advisory Committee, which is an ad hoc committee of the Board of Supervisors, which is essentially looks at ways of facilitating the embedding of a gas industry in our county, there was some discussion of her road law. It was mentioned that the county attorney would look at it, but for what purpose, that wasn't made clear. But it was also said that it's an onerous burden on towns because of the time and the expense of writing a law and doing these studies, etc. So essentially, my question would then be this: are there outside organizations that towns can turn to get help in writing these laws? And secondly, is your law, with a little fine-tuning, perhaps a generic model that other towns can use, and can several towns work together? Because we certainly, I see that we do need some of these laws, but the cost, how can a town afford the cost of these things?
I actually think it is good to check with your town attorney. If you collect a template such as the one from Afton, I think the town of New Berlin has one that's smaller, shorter, and some others, I think that's very good. And the town, both the individuals who come and attend town board meetings and the actual town board members, should look over it and tailor it to fit their specific circumstances. It has been said by several different people that it would be good for all of the towns in a certain area to have similar laws. And there was even some thought that the county might do something generic. But that is not happening, and meanwhile we need to keep moving forward. In part of the process of getting this law, a couple of us on the Afton Town Board went and heard the presentation of Delta Engineering, which kind of has a package for a price in which they do some road testing, and they give you a template of a law. And in fact, the template of the law that's drafted, it was prepared by this municipal attorney who works with the New York Association of Towns. So I think it would be good. I don't see that it's happening quite yet, but I think it's a good idea.
So on the issue of sort of towns working together and the costs and the like, our organization, Community Environmental Defense Council, is helping groups with this. Right now, we're focused, we've sort of promised our services first because we have limited resources to a couple towns in Tompkins County where we started with this. But we're also talking with people from towns outside of Buffalo, and then people in this region, and even further to the east. So we're happy to try to do what we can to help. To some degree, it does require a fair degree of local effort, both on trying to work with your town boards, village boards, et cetera, to have the political will to get this done. And then in New York, you really do have to show some sort of tie to a local condition or concern that you're trying to implement. So there can't really be just one law that sort of gets mailed off to everyone in the state and everyone goes ahead and passes it. It's a little more complicated than that, although that's sort of rightfully so. I mean, these are local decisions, so there probably isn't a one-size-fits-all solution. And then there are towns that are on the defense side of things trying to talk either about putting together some sort of legal defense fund for this, where groups of towns that sort of enacted similar laws would sort of agree that everybody was going to participate in trying to defend these, so that whoever got picked off first wasn't, didn't bear all of the costs. Although with local budgets being what they are and the like, some of those efforts have turned to trying to find outside donors that might have a real interest in some of these areas. Although people that I've talked to who have been sort of making those rounds, people say, well, go pass some laws first and then come back to us. You haven't gotten, you know, sort of out the door yet. So I think that trying to work first and foremost in your town to get some political will towards this when looking to other towns and to other people who have passed or are working on these laws to come up with some sort of approach, even if it's not a per se template, and then trying to work together because the resources on the other side are large, so we will need to do some sort of fundraising or the like to come up with the funds to actually successfully mount a defense to what towns want to do. Because if a town just passes an ordinance that would be effective and does work, but they are afraid, you know, or don't have the money to defend themselves, you know, that would be a shame. So trying to work sort of on all those different things if you didn't have enough to do already.
For the purpose of trying to initiate action at your local level, our experience has been that the first thing that the town people who are, well, whether they're neutral, whether they're for doing something to stop this, whether they're against it, the first thing you're going to hear in our experience is that this local level activity is in fact preempted by the state statute that was talked about, 2303-032. What you heard here tonight is that it's not. We're telling you unequivocally that it's not. I'm going to go beyond what was said tonight. It is not preempted. And to the extent that that becomes the first roadblock or threshold that you hear from your local people on the issue of what anyone else can do and costs and things like that, we will be happy to provide you a written opinion to that effect that goes through essentially the analysis you heard tonight, step by step in detail, and for free, no cost. And we're all in this together. And you're still going to have to go through what you heard about, you know, as far as getting everyone to do things and then moving at the local level. But to the extent that you hear resistance because of this 2303-032, that is just respectfully, and not so respectfully, that's nonsense from the pro-gas lobby, in my opinion.
So just for the purposes of posterity, I'll repeat the question, even though I'm sure everyone here heard it, which was asking if you have a comprehensive plan, but it hasn't been implemented, and your comprehensive plan is specific enough to not provide for or affirmatively provide that you don't want a specific use, would that be an enforceable way to keep a use out of your town? And the answer is that a comprehensive plan in and of itself is not an enforceable document in and of itself. If a town has a comprehensive plan and they go to implement zoning, it has to be consistent with the comprehensive plan. So you can use the comprehensive plan as a tool to ensure that zoning follows that plan. So that if a comprehensive plan affirmatively said there will not be any, you know, we don't want industry in our town, we want to preserve our rural character, we want to promote tourism and organic agriculture, and all these other things are inconsistent with that, and the town board wanted to pass a specific zoning law authorizing a nuclear waste plant in your town, you could go to court and say the town board has no authority to try to pass this kind of law, it's not provided for, and is contrary to our comprehensive plan. So you can use it defensively. These siting commissions that you're talking about, which also relates, FERC is sort of like that, the pipeline siting company, they won't allow, and there's issues with sort of public utility corporations where you can't entirely exclude, you couldn't say we won't allow electricity transmission lines through our town. They wouldn't let you do that. But if a town says we think these locations are better for electricity transmission sites than these this location. Go around the forest, don't go straight through the forest. FERC has said that they will consider and take into account those siting things, even if they weren't a mandatory part of zoning. If a community could point to some sort of plan that it had that wasn't entirely exclusionary in the case of pipelines and other transmission facilities, but if they had a hierarchy of sites, or if they had some sort of, critical environmental areas or something that indicated certain sites were less suitable than others, FERC as a siting commission type group will look at those things. The DEC has indicated absolutely no willingness to talk to anybody about anything, so you're probably not going to get too far without without a fight on that side. But so it would depend on the siting commission, and the comprehensive plan in and of itself wouldn't be enough to actually enforce anything, but it could inform a decision. So the question again is what on the preservation of jurisdiction over real property taxation, what are there any creative things towns might do on the real property side? The assessment of oil and gas properties is regulated by the Office of Real Property Services in Albany, and they have issued a number of opinions and procedures for how natural gas rights and production are supposed to be assessed, and determining when when things get assessed and taxed separately, and when they're sort of still all just part of the regular land use. And there are limits on what some people have said, well, what if we just say in our county, the assessment rate for this, for oil and gas production is 60%, some huge number, and people won't produce. There are constitutional limits on the percentage of various taxes that can be issued. So, so it hasn't. I haven't gone. There's a lot to think about there, and I haven't answered sort of the whole body of law on property assessment. But it looks to be pretty complicated, even to figure out what the state scheme is, and then to trying to figure out ways around that. I don't think anyone's found any particularly interesting ones, and there is a fair amount of sort of documentation and regulation about how it has to be done. So it hasn't looked, we haven't found that to be promising yet. But so yes, there's at least in Tompkins County there is a group of people specifically looking at assessment type issues and what could or might be done, trying to have laws requiring at least metering, because if you're going to tax production and it's totally self-reported, don't we all wish we got to, I think my house is worth $3. So to require metering and certain kind of audit rights and the like, but that's sort of that's as far as that's gotten. So people are thinking about it, and so far nothing has sort of jumped up as the solution. So the question is, if a town has entered into road agreements with a particular gas company, is the town precluded from enacting a road use law? And I would say no, that the town, even if the town, and I could see a gas company putting into their road use agreement that the town agreed to not enact any laws, I don't believe that would be enforceable against a town, because the town doesn't have the right to sort of contract away its ability to pass laws. So I would think not. You have more experience.
But I would basically agree. You could still enact a road law. The contract that you had with that particular, if it was with one particular gas company, that contract would still be enforceable for the period of time of the contract. Of the agreement, yeah. So like if the agreement, there was a voluntary road use agreement, usually the ones I've seen, it's been for 1 year. So if there were still 6 months left in the year contract while the road law was passed, then the contract would apply to that particular signatory to the contract until the contract had lapsed, and then the road agreement would apply to that and all other companies. So the question is, if you have a town that is allergic to zoning, or as we call it, the dreaded Z word, right? The dreaded Z word, can you get the same protections from what? Site plan review?
No. If you put in specific land use regulations.
Well, you need a comprehensive plan and all of that, and I'm going to actually let Helen talk about that because I think she has a much broader knowledge of that than me.
So when we have looked at this issue, land use regulations by definition are zoning, so that if you don't have any sort of comprehensive, and you need a comprehensive plan, or at least a portion of a comprehensive plan to enact zoning. So there's sort of two routes you could take, one that's a bit more preferable, we think, than the other, but the first would be to do a bit of comprehensive planning solely looking at, say, for instance, high impact industry, and deciding, you know what, we can't agree on anything in this town about zoning, about agricultural zoning, about residential zoning, about commercial zoning, but we know one thing, and we don't want high impact industry in our town. And you do comprehensive planning just on that little piece, but you go through the process of some comprehensive planning, and this will take, you know, this isn't going to be overnight, and then you pass a town law in accordance with your comprehensive plan that prohibits high-impact industry throughout your town. That would work. Now, you would have to use the zoning word. So there might be towns where just mentioning zoning, even if it was on this little piece, might not be appealable. You know, people might not find that appealing. Another option that is not as, we don't believe is as strong as going the land use route, given the language and all the cases that Mary Jo went through that talk about zoning and land use regulation being not the regulation of industry, is to rely instead on the police power. And the police power includes zoning, but it includes a number of other types of things: protection of public health, protection of public safety, reducing traffic congestion in the streets, and to pass other laws in your town that are not specifically land use based, but that are, and some work would have to be done on this, but that relate more to the police power and are not real zoning issues, and pass those sorts of laws in an effort to sort of to work on the issues that you can reach agreement in your town. So to sort of peel it off from zoning and have it be more of a police power other than zoning type law. But you couldn't just call it police power and not zoning if it really was zoning. So the question is high impact industry a defined term, and where can one find the definition of high impact industry? I've used that a couple times tonight. High impact industrial activity, or we should trademark it. That's our, in trying to come up with a description of what the problem is, because industry in and of itself sort of necessarily requires, I mean, this, in part the definition most towns use is there's a bit of a nuisance factor with industrial use, but they believe it can be contained or mitigated. And so the idea of high impact industry is basically, I mean, some of the other sort of synonyms that we're thinking of were sort of noxious industry, hazardous industry, nuisance industry as sort of the concept. But the real sort of complaint when you think about what makes you stay up at night and why don't, what are your concerns about gas drilling? Well, it's not some, if one really could just get the gas up out of the ground with no impact on everybody's roads, everybody's air, everybody's water, and a landowner could simply just do it on their property and it was not a nuisance, well, no one would have a problem. We wouldn't all be here tonight. We'd be doing everything else that we like to do. It's because of this risk to the community at large. So we felt that high-impact industry picks up that concept, that this is an industry that has a high impact on the community, and that therefore a community might decide it doesn't want, and that it should have the right to decide that it doesn't want something because no one has a right to a nuisance. So the term is not defined in the legal literature or in New York state law. It's a definition we've crafted as part of our sample ordinances, and is that a problem? No, I mean, none of these things are sort of, I mean, each town, when you look at their zoning, will call different zones different things. They make up, you know, mixed industrial and technology district a town might have. Like, what's that mean? You know, like, and that's literally, I mean, we've been reading lots of zoning codes lately. So every town sort of, through comprehensive planning, comes up with the sorts of districts they want: conservation zones, lake source zones, Route 96 corridor zones. So you're allowed to, that's the whole idea, make up what you locally want in your town. So you ultimately define that in your zoning ordinance very specifically. Perhaps it's that it's a use that involves the generation of solid waste for which there's no known way to properly dispose of. Perhaps it's that it involves, you know, the injection of fluids, you know, whatever it is. Perhaps it involves more than 50 trips per day over more than 4 days of trucks that are more than 6,000 pounds. Like, so each town would craft and approve sort of its definition of that term, but the idea is for that term to get at precisely the issues that the people in that locality have agreement upon that they don't want, and to use that as your definition. Question is basically, what can towns do about pipelines, specifically these gathering lines that are not regulated by the PSC or the DEC, that simply have to be operating at less than 125 pounds, are supposed to be operating at less than 125 pounds per square inch, but could be designed and actually operating at higher pressures. What can towns do to try to regulate these? And so the first answer, which I'll defer to Mary Jo, because it sounds like she has some experience with, is a moratorium, which has to be enacted for a reason. So you'd have to say, because we're going to be doing zoning, or we're going to be introducing, you know, some sort of local law on the police power about, you know, pipelines. But a moratorium would be the first step, and I believe you're the expert.
Yes, so one of the things that you could do is the town can pass a moratorium. And a moratorium is simply a pausing. You have to kind of lay out in the sort of purpose for passing the moratorium, the reason you're doing it. And I'm not as much of, have as much experience in terms of zoning, but in terms of a moratorium, it doesn't have to be that you're pausing the activity temporarily while you do a comprehensive plan in zoning. You can do it while you're studying and looking into enacting laws under the police power with regard to these lines, which are not preempted because no other level of government is taking responsibility for it. So if your town wants to you know, think about designing some laws to deal with the public safety and health concerns of unregulated gas lines below 125 pounds per square inch, you could do a moratorium. A moratorium has to be very specifically defined, you know, 3 months, 6 months, you know, whatever would be a reasonable time for you to do the investigation and research and prepare the law and pass it. But a moratorium is sort of the tool that is used in those situations. The question was, does it have to be done as a zoning law, if I understood you right? And that was, I was going to defer to Helen on that. I mean, I think of it as under the police power, and certainly zoning laws can come under the police power. It has other provisions. The police power is broader, and I look at it as more of a, well, anyway, I mean, I was looking at it more generally under police powers rather than specifically zoning, but it may qualify under zoning too. I'll ask Helen.
So the issue in when a town enacts a moratorium, it has to be for, you basically have to have permission to do the underlying action that you say you're going to study. So if you phrase your ability to regulate the pipelines as simply a matter of public safety and not as a land use regulation, then I believe that you, without zoning, could enact a moratorium to study the pipeline issue as a public safety issue. You just want it to be consistent. You wouldn't want to say that you were enacting the ordinance or enacting the moratorium under the police power and then say, because we want to study, you know, the proper placement of gathering lines, because that's really a land use, that's sort of a where, as compared to a more of an operational type issue. So you can run into some of these towns that have passed moratoriums on saying they want to look at the regulation of gas drilling. The way I would look at that is that if they didn't have the power to regulate the gas industry, they don't have the power to put in a moratorium to study regulation of the gas industry, because they don't have that power. So you'd want to make sure that whatever you said you needed to study and how you said you were going to do it was consistent, so that you had the, you know, sort of your police power to police power, Wonder Twin powers to Wonder Twin powers, but that, you know, it sort of matched up and you made sure you had the authority to do whatever it was you said you were going to study, just so it wasn't overly broad.
Okay, so I'm going to repeat that question. Presumably some town at one point stated they had a law regarding seismic testing which required the adjacent landowners to be giving permission. And to your knowledge, every time you've asked for that law, it turns out that it's more of a policy rather than a law. And the question then is a policy as good as a law? And so there was a lack of even a written policy, and my opinion is that it's not enforceable if it's not in writing, and it's not, and the policy is not the same as the law. We had that issue in the road preservation law because some of our board members wanted a road use agreement. They didn't want a law. They wanted an agreement, but you can't force people into agreements. And really, anything that's unwritten is subject to challenge and not really enforceable, and not a real policy. A policy has to be in writing, and it really should be passed. Now, if it's not a law, you can have resolutions about things. Towns can pass resolutions. It's not a law that's enforceable. It's just saying, we want the state legislature to do such and such.
The question is about how do you balance, or how does the law treat the rights of individuals to sort of clean water, clean air, and peace and quiet versus a landowner's or gas company's right to extract under a lease. And this is another one of the major issues that gets brought up. And I think there's a number of answers to that, ranging in complexity, but the first and foremost answer I alluded to earlier is that no person has the right to use their land as a nuisance. And to the extent that the only way that the natural gas can be extracted from the pores of rocks presently is through a manner that requires truck traffic, introduction of chemicals into the subsurface, methane emissions that are going to tip our planet potentially in, with climate change and the like, that you just don't have the right to do that. And that everyone, even Justice Scalia, has said that the rights to people's property are subject to the background principles of property law. and that one of those basic background principles is no right to a nuisance, and that a government has the right to regulate and decide what appropriate land uses are so as to limit the imposition of nuisances on everyone else, and that is not a taking. So that, I mean, I could in my backyard, what if I wanted to have a nuclear waste dump? What if I wanted to open a gambling casino? You know, what if I wanted to, you know, do any number of things? You know, you can't do it. And the government and everyone agrees we live in a society where no person really, there's this conception of, well, the landowner owns his land and can do whatever he or she wants to do with the land. But so does but if everyone has that right around that person, you sort of can't, I mean, the basic principle of law, because of that conflicting rights, is that you can't do anything with your land that negatively impacts the people around you. And there's presently, as I see it, no way for that gas drilling to be done, the sort we're talking about here, without negatively impacting the air, the climate, the land, the soil, the water, and therefore there's no right to do that. So you're not taking anything away from someone. They never had the right to do it in the first place.
So the question was, are there any remedies that have been developed to deal with the misleading landsmen's promises to induce the signing of leases, where the verbal promises far exceed what the lease gives? Yes.
And there's no lawyer reviewing.
Oh, and no lawyer. Yeah, of course.
Reviewing for the owner.
I mean, my top.
No lawyers.
No lawyer negotiating for the lessor. And one of the things I didn't mention tonight, but I did see some reference to the possibility of actually local ordinances regulating landmen. There had been I think there was some voluntary code of ethics for landmen that never got followed, and there was some talk about passing statewide legislation, but it didn't happen. And again, this is not preempted, so it may not be practical for all towns, but a town or a local municipality, a county, could pass a statute with a code of ethics and regulations of the practices of landmen, which would perhaps help that problem in the future. That doesn't deal with all of the people who have been misled into contracts in the past. And I wish that the Attorney General of the state of New York would have taken a more aggressive position in following up on those clearly fraudulent practices. That would be, in my opinion, the appropriate person to have done it. But he instead has become the governor.
So on the issue of remedies, it's a very difficult fact-specific case. Although there is a group called Fleeced, F with then the word least, another radical Tompkins County group, although with members, including one here in the audience, and they are working on trying to identify, because part of what the Attorney General's office said is, well, there really aren't very many of these people, and two, all they want is more money, and we are not in the business of, you know, renegotiating leases to get people more money. The Fleeced group is primarily, or exclusively, I can't speak for everyone in it, but people that really just want out of their leases. They don't want more money. That's not the solution. So, so talking with that group and sharing your stories with them. They have a site, fleeced.org, and that helps sort of everyone, to the extent that they're talking with the Attorney General, to say, no, there really are a lot of people, there's common practices, and they're investigating the possibility of a lawsuit, basically a mass tort type action of landowners across the state. So, you know, that may be, so that's something they're working on, but they it's sort of like a chicken and the egg. They need the people to come forward with the stories, and there are a lot of people that are embarrassed about their stories and don't want to participate or think it's just so hopeless there's nothing they can do, why talk about it. And people, and then other people that they ask, tell us about your lease, they're like, I don't even want to open that thing up. Like, it's like when the stock market crashed and nobody wanted to open up their 401k statements because they didn't want to see what it said. People don't want to look at their leases. But sort of the first step is admitting you have a problem and reading your lease, talking to Fleeced, and or perhaps other organizations that might be out there, but Fleeced is a good one on that. Two questions, the second one first. The second one is, can counties regulate in the same ways that townships, villages, or cities could? And the answer is no, that counties do not have zoning powers. Counties do have some limited powers to pass general laws. There's also possibilities for intermunicipal control, or intermunicipal agreements where multiple municipalities might agree to act in a similar fashion on an issue, but each of those towns has to agree and to the same thing. And so I think, I know counties can do some wetlands regulations and things like that, but it's pretty limited at the county level. And the first question, I forgot. Water testing. What provisions exist or mechanisms exist to require gas drilling companies to do water testing prior to drilling, or to pay, and to pay for it, or to pay for them to do independent testing. Which gets to a very important issue. It's one thing to have the gas drilling company go out and do testing and have their lab do the testing and have the results. In Pennsylvania, they don't even necessarily have to share those with the landowner, versus doing your own testing for the things you want done and getting the results. So in New York State, there's presently nothing that touches that. The hope is that the draft supplemental, or when the second draft comes out per the executive order of the generic impact statement, that will have some requirements for water testing. There's a group, again, out of Ithaca called the Community Science Institute, and they're a nonprofit that's doing water testing, and they have some money, I don't know how much is left, but to do pre-drill testing for people, I believe. So the communityscienceinstitute.org is one place to look for parameters for testing, the lowest cost testing that you're going to get, and they know specifically sort of what to do for gas drilling, and but trying to get reimbursed for that by a gas company, not yet, and probably not. Even in Pennsylvania, that's not possible. Can towns or counties mandate that oil and gas companies put aside money for water testing? I believe that would be considered a regulation of the industry and not allowed. Perhaps a town could require that anyone doing any sort of drilling to a certain depth, although that also gets into regulating, so it would be hard for a town to do that. You'd have to try to very carefully craft a way, perhaps more connected to the Safe Drinking Water Act and the Underground Injection Control Act, that you were somehow doing testing relating to that and not per se the oil and gas industry. So that's a very interesting idea, a tough one, but one that somebody could think about. The question is, so let's say you actually get your town board to pass a law barring high impact industrial use, what then? That's a guess. There's a couple different paths. One is that either a landowner or the gas company immediately sues, in which case you'll wind up, first off, before anything else is going on, litigating the propriety of that local law, although we believe that a town would ultimately, with all sorts of, properly presented and argued and the like, that they would win on that case. There's the possibility that also that lawsuit would challenge this as a taking, which, as I described before, we also believe a town would win, that this wasn't, that this wouldn't be a taking, the passing of this kind of law. So then either assuming no one challenges the law or challenges are won, then the question becomes, so the DEC just decides to go ahead and issue permits without regard to the local law. Then the town or citizens acting to enforce the town's law would then have to take the DEC and the landowner and the permit holder to court to seek an injunction to stop that work. So that would be, so you'd have to undertake some, you'd have to keep an eye out on sort of what permits and stuff were out there. Perhaps with the change at the DEC, there's a liquid gas storage facility going in the Watkins Glen area, and in that instance, and there are somewhat different rules about these larger storage facilities, but Pete Granis, the former commissioner of the DEC, wrote an opinion on sort of who the lead agency should be. In that opinion, he talked about whether or not there was any sort of local zoning control, and noted that the town in question had made no application or expressed any interest or argument in why it got to exercise control. So perhaps if a town did make that argument to the DEC, particularly with a new commissioner and a new governor and a new attorney general, things would be different and they would actually listen. Or otherwise, assuming that didn't happen, you'd have to go to court.
I'll go with that.
So as we say in the trade, you've bought yourself a lawsuit. So, but.
Well, I thank all of you for coming. It's been a long night.